Our next speaker is Wyatt Connolly, and this topic is enforcement under the Texas Water Code, essentially discussing groundwater district authority. And he is an attorney with Kemp Smith here in Austin, and he does specialize in public and environmental law. I think there's a robust bio in the back. And of our brochures, I understand that you've been around the groundwater world a while, and we appreciate you coming and speaking.
Good to be here.
Thank you. Appreciate it, Wyatt.
Yeah.
It's a good name.
Appreciate it.
Okay.
All right, good afternoon, everybody. My name is Wyatt Conley. I'm an attorney with Kemp Smith. I work with Deborah Trejo and Drew Miller, representing groundwater conservation districts and other clients around Texas. So my presentation today is about enforcement under the Texas Water Code, what your authority is as a groundwater conservation district, what changed this year, and how to enforce in a way that's effective and legally defensible. So I want to start out just with a little bit of a roadmap about what we're going to be talking about. We're going to start off just by discussing preventing the need for enforcement altogether, what steps a groundwater conservation district can take just to build a culture of compliance. I mean, that's the goal, is to not have to enforce. So we'll start off talking about that. We're going to talk about the duty to enforce that's in Chapter 36 and the risks of inaction of not enforcing your rules. We're going to be talking about where your enforcement authority comes from, the primary tool for enforcement, which is Section 36.102. And then we're going to be talking about House Bill 5560 and what changes that made to the enforcement provisions under Chapter 36. And as part of that, we're going to be talking about the new B1 factors and how that can create an evidentiary checklist for groundwater conservation districts as they're preparing and documenting for a violation. We're going to talk about deferring part of the penalty, the new Section 36.1021. Courts are allowed to defer up to 50% of these penalties and use that toward building compliance, remedying. We're going to be talking about the steps that you can take before you sue, compliance and settlement steps. We're going to talk about picking remedies, calculating liability. And then we're going to finish off with discussing just attorney's fees, how groundwater conservation districts can get made whole. And also talk about, oftentimes groundwater districts, when moving forward with enforcement, are threatened with federal civil rights counterclaims. Just going to briefly discuss some of the nuance around the attorney's fees associated with those counterclaims. And then just a practical workflow, bringing it all together to allow groundwater conservation districts, kind of give them a checklist to go through as they're preparing for enforcement. Okay, so ounce of prevention is worth a pound of cure. So the best way for the district to protect its aquifers is to build that culture of compliance that we were talking about. And I think the two best things that a groundwater conservation district can do is to have well-communicated rules combined with proactive educational outreach. Makes a really good cocktail for avoiding disputes and fostering cooperation. So on the proactive education front, a skilled general manager and staff can be the district's best first line of enforcement. So meeting and educating stakeholders, answering questions, and ensuring people just feel comfortable approaching the district. Many issues can be resolved before they become violations. But even the clearest rules and the most active outreach isn't going to prevent every problem. Some individuals are going to disregard the rules altogether or refuse to work toward compliance. So in those instances, you've done your part, and the district has to consider whether it's time to take formal enforcement. Let's see here. Okay, so Texas law on enforcement. Texas law doesn't just allow you to enforce. It expects you to. So the duties laid out across various sections of Chapter 36. Under Section 36.101B, that section states the board shall adopt and enforce its rules. Section 36.113 makes requiring permits for drilling, equipping, operating, or completing of wells non-optional. And then under Sections 36.1071F and section 36.1085, it's required that your rules implement your management plan and align with DFCs. So the legislature has also built in oversight mechanisms in case districts aren't fulfilling that duty. So if districts repeatedly look the other way, Chapter 36 allows, one, for a state auditor who can audit the district to review whether it's been actively enforcing its rules, and then make a determination that the district is either operational or non-operational under section 36.302. Under section 36.3011, anyone who qualifies as an affected person can petition the TCEQ if they feel that the district's failure to enforce substantial compliance is leading to the groundwater in the management area not being adequately protected. So if either of those processes go badly for the groundwater district, then section 36.303 allows for the TCEQ to take certain actions, among those dissolving the board and holding a new election, or requesting that the Attorney General bring suit for the appointment of a receiver to collect the assets and carry on the business of the Groundwater Conservation District. Okay, so where your authority comes from. Chapter 36 grants groundwater conservation districts broad authority as to how they regulate groundwater, leaving it to districts to determine how best to carry out their obligations to protect groundwater and those dependent upon it. So section 36.101A states, groundwater districts are authorized to make and enforce rules to provide for conserving, preserving, protecting, and recharge of the groundwater in order to control subsidence, prevent degradation, prevent waste, and to carry out the powers and duties provided by the chapter. And so when evaluating a district's authority, groundwater districts should also always check their enabling acts. So those enabling acts can supplement or supersede Chapter 36 in places. There's also Chapter 49 and 51 of the Water Code, which should be referred to, Texas Occupations Code 1901 and 1902, and also refer to the DDLR rules. Another section worth flagging here is section 36.118. That authorizes districts where a landowner fails or refuses to close or cap a well in accordance to the district's rules to enter property in order to close or cap the well and provide for the district to take a statutory lien to recover its costs in doing so. Okay. So getting into section 36.102. So this is the meat and potatoes of the district's authority to enforce its rules. It's an important section to familiarize yourself with. So whether you're dealing with well spacing violations or overproduction, drillers improperly drilling their wells, or unlawful exportation of water, districts are going to be relying on section 36.102. So section 36.102 gives groundwater districts the authority to enforce Chapter 36 and their own rules by filing lawsuits for injunctive relief and or civil penalties in a court of competent jurisdiction. Under section 36.102B, the district's rules will set the penalty range of what the court may assess, subject to the statutory caps. And some of those statutory caps, that statutory cap has changed, and we'll get into that on the next slide. Penalties stack by calendar days and counts. So it's important for groundwater districts to document every day the conduct continues and every discrete violation. Okay, so the big update in this session is that this House Bill 5560 made some changes to section 36.102 and changes to enforcement. So the first update in section B, the penalty cap was previously an amount not to exceed $10,000 per day per violation. It has been changed to amount not to exceed $25,000 per day per violation. Another big change is that under the newly added subsection F, courts are now explicitly authorized to impose penalties exceeding that new $25,000 limit if the violator gained an economic benefit that's greater than the allowed penalty. So the court has the authority to impose a penalty greater than the $25,000 limit, and can go as high as it needs to in order to outweigh the violator's economic benefit and deter future violations. So on that, for example, if you have someone with a 2-day violation where the maximum penalty allowed under the district's rules and subsection B is $50,000, but for one reason or another, the violator gained an economic benefit of $100,000, it's unlikely that you'd be able to determine that prior to filing suit, because you'd need to be able to figure that kind of stuff out through discovery. But assuming that you'd figured out that they'd obtained an economic benefit of $100,000, the court's authorized to penalize the violator in an amount in excess of the violator's economic gain of $100,000. They can go as far as they need to ensure that the penalty outweighs economic gain and discourages future violations. Okay, there is also this new section B1 that was added to section 36.102. So these are a list of factors that the court must consider when deciding the amount of a civil penalty. So this is important. So courts are going to look for evidence of these items when determining the amount of the penalty the district is going to be awarded. So the district should be sure to document evidence of these factors, because this is going to become part of your evidence checklist. Oh, sorry. It's okay, I hopped out of that. Okay, so the factors fall into 3 buckets. The first is the violation itself. So courts are going to look at the nature, the extent, the duration, the gravity, with emphasis on impacts to groundwater, other producers' rights, public health and safety, and other water resources. So they're going to take a close look at the violation itself when determining the amount of penalties of this $25,000, and whatever, combined with whatever your rules allow for. Then they're going to look at the violator. They look at the history of violations, the degree of culpability. Was this something that was foreseeable, where the violator was able to say, I know what I'm doing, but I'm doing it anyway, or was it just a mechanical or electrical failure? They're going to evaluate good faith efforts to fix and compensate, any economic benefit, which kind of falls under that F section that we talked about before, and what it takes to deter. There's also a specific factor for entities with drought contingency plans when overproduction is the issue. Lastly, there's just a catch-all that allows the judge to take into consideration any other factors that they feel are relevant. Okay, so when you are building your documentation for the violation, it's important that you think about these factors and you document each one of these things. If you're having good faith outreach and are being met with malfeasance, basically, that should be documented, because that's going to be an important thing for the court to be able to see when it comes time. Okay, so deferring part of the penalty. So this is a new section as well that House Bill 5560 adds. This lets the court defer up to 50% of the civil penalty if the violator spends that amount on corrective actions that mitigate the violation or prevent future ones. So if the court utilizes this deferral authority and says, okay, I'm going to allocate a certain amount of the penalties that I would otherwise award to the district, I'm going to allocate that to the violator with an order that says that this party has to spend that amount on mitigation and prevention. But in evaluating that amount, the court's going to think about the 36.102B1 factors that we talked about before. They're also going to verify that the non-deferred amount plus the attorney's fees to the district is going to make the district whole. So they're not going to defer an amount that's going to leave the district in a worse place than it was before the violation, and weigh the violator's finances, alternatives, risks of delay, and any essential public services. Okay. All right, so before you sue, and some of the steps to take prior to, so just a precision point about district authority. There does not appear to be anything in Chapter 36 for districts to assess fines for penalties. The only authority is to set a penalty schedule for violations and an entitlement to an injunction and civil penalties assessed in civil litigation. So you do have to it does appear that you need to go to litigation to enforce your rules. But the district can and usually should offer to settle its claims with violators instead of immediately bringing them to court. So prior to reaching out to the violator with a notice of violation and demand, the district should take the time to calculate per-day exposure of the violation, build up its documentation, taking into account factors in the new B1 section of Section 36.102. Should also probably think about the amount that it would be willing to defer for the purpose of correcting the problem. All of that should be built in or considered in your offer of settlement. So these pre-suit settlement agreements may be drafted by the district's attorney and staff and then presented to the district's board for approval. All right, picking remedies and calculating liability. When you do sue, you need to be specific about what you want and why. You need to tie each violation to a rule citation and the evidence. You need to have documented the conduct, the dates, the daily counts, document the harm to management goals, ask for temporary and permanent injunctive relief tailored to stop the conduct, compel compliance steps, and bar recurrence. So for penalties, count days and counts carefully. Each day of violation continues, and each separate violation. Those are all separate assessments within your rule range. Make sure you have documented and analyzed the 36.102B1 factors and quantify economic benefit. It's really important that the district, when it believes that it's going to pursue enforcement, begin working on that kind of documentation. Okay, attorney's fees and getting made whole. So on fees, Section 36.102D provides that if the district prevails in a suit to enforce its rules, the court shall award your attorney's fees, expert costs, and court costs. Now, oftentimes you're going to face, go back. All right. Now, oftentimes you're going to face circumstances where you have a violator threatening to countersue, or they're threatening to sue before you even pursue violation. If they do, 36.066G gives you fee recovery in the interest of justice if you prevail on the state law claims, including state takings claims. If you win on some claims against you but not others, 36.066H requires segregation, so groundwater attorneys need to track time by issue from day one. And this is just a little bit of a, off topic, but I know that it so frequently comes up with groundwater conservation districts assessing the cost of litigation when dealing with federal civil rights counterclaims. So these are claims that are brought under Section 1983. The usual bundle is federal takings, due process, equal protection, brought as claims against the district by an alleged violator. If these claims are brought, neither Section 36.102D nor Section 36.066G will govern the standard for the district to obtain its attorney's fees. And that's because the federal government isn't going to allow states to change the attorney's fees associated with federal claims when they already have an attorney's fees provision. And the attorney's fees provision that determines the rule associated with whether you get your attorney's fees under Section 1983 is Section 1988. Which only awards fees to a prevailing district if the claim was frivolous or unreasonable. So the frivolous and unreasonable standard is high, so even if you win, you may carry your own fees on the federal side. A little bit of a side point, Texas and federal takings are analyzed identically. So if you prevail on the state takings claim, 36.066G should give you attorney's fees for that. And you won't be required to segregate because the analysis is the same, so you'll essentially get your federal, the fees incurred as a result of defending the federal claim of takings as well. Okay, so just a practical workflow that groundwater districts can use. Okay, so first you want to start out with proactive education and clear rules. You want to inspect and verify, make sure that you have an actual violation before you go on trying to enforce. Determine whether you can work with the violator. If not, begin your documentation, identify days, counts, build your B1 facts and economic benefit analysis for exceeding statutory cap. Like I said, you may just have to wait till discovery to be able to actually demonstrate that an economic benefit that exceeds the statutory cap is what you're dealing with. Send notice of violation, demand settlement proposals. If you reach a settlement, draft it up, get board approval. If you can't reach a settlement, file suit if needed, seek injunction, penalties, and fees. And that's all. Yeah, of course.